Okay. Okay. Item 36. Okay. Uh, Upon instructions, Mr. H. Ali, learned counsel for the review petitioner, seeks to withdraw the writ petition and the connected interlocutory application with liberty to approach the court again to challenge the to, again. That's all. Next para, the so and so for the respondents are present. Next para, matter stands dismissed on withdrawal with liberty as paid for. 12. Is a 2017 matter. Please wait. No, it's okay, but we'll have to see the records. There are too many old pending cases. About the registry is informed that about more than 200 cases, old pending cases are pending. We'll have to take it up. Because this is being listed specifically. Every day, 4-5 matters of old. No, I don't know. Let us see the records. After that only. 2016-17 matters I am not adjourning. Because the registry is informed that more than 200 cases are pending. Okay. Yes. 40. Okay. Upgrading. Yes. We'll see. Let the courtmaster take a call. We'll upgrade it. All listing, give it to the courtmaster. Next. 30. 34. Okay. Adjournment slip was given. Okay. Both sides are represented. On the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List after 2 weeks. This is a review petition. Give a date after 2 weeks. 28. Okay. You want an adjournment? Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. List after 2 weeks. Okay. Okay. Seven. Okay. When do you want? I can't hear you.
Item number 7,
But, after how many days?
1 week. Maybe
Okay.
I'll check for 1 week.
Which was represented on the prayer made by learned counsel for the petitioner. List after a week. Okay.
Item 38, Lordship, I am praying for adjournment, Lordship. It was Lordship directed to file a fresh affidavit, Lordship.
38.
Earlier affidavit filed by us, Lordship, was lacking in some disclosure of
Okay.
Lordship.
You have taken consent of the other side.
No, I have not taken, but could not
Then
file.
let the matter be called.
Supplementary item 43 for delivery of orders.
The matter is dismissed at the motion stage without issuance of notice of the respondents. This we have directed you to transmit a copy to the concerned authorities.
Yes, sir. Blessed.
Item 1 for motion.
Mid-page amendment. Your Lordship, the impugn order here is on page 58, Your Lordship. Your Lordship, records were called for in this matter. Your Lordship, it is above, Your Lordship. Above I have pasted it, Your Lordship. Page 79, Your Lordship. 79. Your Lordship, that is the track report. Yes, yes, sir. Yes, track record, Your Lordship. Your Lordship, I have not yet annexed it, Your Lordship. Your Lordship, ask me, I will some report, Your Lordship. I'll correct it. Lordship, Lordship. Lord, Lordship. Lordship, I have prayed for this review petition because your lordship, there are certain grounds, your lordship, which we wanted to place before the tribunal, your lordship. Because your lordship. Yes, your lordship. Not taken, your lordship. It is still lying before the tribunal. It has not been registered, your lord. Lordship. Lordship, Lordship, I will check it out. I'll check it out and I will place before this court. Lordship. Lord. Lordship.
Not granted you bail, we can also permit you to find it out by 2 o'clock and bring it. At 2 o'clock also we are prepared to take it up.
Can it be tomorrow then, your lordship?
Not tomorrow, day after tomorrow,
after.
because we have matters fixed. Uh, Both sides are represented. We direct the Learned Counsel for the petitioner to produce a copy of postal track report with regard to the communication sent by the annexure 19 to the petitioner. Next paragraph, based on is 17/10/2025. But this is serious. Last time also we took steps because some protocol has to be put into place.
Yes, sir. They have filed a petition, lordship, that should be accepted, lordship.
It should be recorded.
Yes, sir.
This is something. Just check up this record. We did not find it, but you may find it out. Just wait for some time. That
Your lordship, they have not registered it. They have said that we will not accept it and.
okay.
It
That
should not be there.
that is, no, not it. Okay, all right.
No, no,
Okay.
For motion, item 2, 3, and 4.
My lord, 2 and 4 have been filed by the nephew of the detainee. On the last occasion, your lordship was pleased to grant us permission to go and get wakalatnama. We got it, my lord.
Just a moment. Item number
2 and 4.
2 and 4 was filed by the nephew.
All 2, 3, and 4 filed by the nephew of the detainees. On the last occasion, your lordship was pleased to grant us permission to go and get wakalatnama. So now we have got the wakalatnamas and filed the petition in the name of the petitioner, which just now I have mentioned it. We filed on 26, my lord, and we have mentioned it for day after tomorrow. So everything may come day after tomorrow, my lord.
Both sides are represented on the prayer made by the council petitioner based on 17/10/2025.
My lord.
Item 5,
May I please, Your Lordship? Lordship, this case is a little bit exceptional, Your Lordship. In this case, no proper order has been passed by the tribunal, Your Lordship. A order I have annexed at page number 22, Your Lordship. It has been provided. Typing copy is at page number 21, Your Lordship. Then what happened, Your Lordship? Case number is case of 2011, Your Lordship. One notice has been issued, Your Lordship, to the petitioner, Your Lordship. And after the process server report, after issuing the notice, Your Lordship, the process server report speaks that, Your Lordship, the petitioner was not traceable at that time, Your Lordship. Further, Your Lordship, one Gaon Budha report has been relied on by the process server. The Gaon Budha speaks that there is no such type of person in that locality, Your Lordship. Relying on that report, Your Lordship, the foreigners tribunal number 2 pass an order informing SP border to take action without passing any ex parte order, Your Lordship, and bans assistant to take steps for the compliance report. That is the order, Your Lordship. Nothing I have get, Your Lordship. Nothing I have obtained after applying for the certified copies. I get this thing on Your Lordship from the foreigners tribunal number 2. Now, Your Lordship, I approach the foreigners tribunal number 2, Your Lordship. Foreigners tribunal number 2 inform us, Your Lordship, there is no such record, Your Lordship. I am submitting from my knowledge, Your Lordship, as construction, Your Lordship. Now, foreigners tribunal number 2 states that type of cases, Your Lordship, the jurisdiction has been changed, Your Lordship. Now, the cases from her locality has been transferred to foreigners tribunal number 8. I approach foreigners tribunal number 8 also, Your Lordship. Now, foreigners tribunal number 8 stated that there is no such type of case. For that reason, Your Lordship, I have arrayed both of them as a party, Your Lordship, in this case, Your Lordship. And it was not within my knowledge, Your Lordship. When the final, my name has not been in the final draft list of NRC, Your Lordship, in the year 2019, then only I got to know that a adverse order has been passed by the foreigners tribunal number 2. And the order is not proper, Your Lordship, so that I couldn't even appear before the court, before the tribunal to set aside the ex parte order, Your Lordship. For that reason, Your Lordship, I am before this honorable court, Your Lordship. Another tribunal,
You went to that tribunal, you did not find it.
nothing.
Can you find it out? What the proceedings? Transferred from which tribunal to which tribunal?
But foreigners tribunal number 2 to foreigners tribunal number
No,
8.
number 2 at where?
Number 2 at Nagaon. In the Nagaon itself, Your Lordship. Both of the tribunal,
Acha. From Nagaon to it has gone where?
foreigners tribunal number 8, Your Lordship.
8, Nagaon.
Nagaon.
We have this one.
And where is the order of the tribunal?
Here, Your Lordship, 22, Your Lordship. That is the order only, Your Lordship.
Page?
22, Your Lordship.
2013 order.
13 order, Your Lordship.
We think that the state should have come up in by filing a writ petition.
No.
You look, read page 22. It's not very clear. You have a good copy of page 22?
This is a certified copy, Your Lordship. This is a certified copy, Your Lordship.
Give it to Mr. Sharma.
Legibly, no.
Copy number 1. No, I think it could not be posted in the meeting of the- Okay.
You understood what it is written? Service report accepted, case
Yes.
filed.
Yes,
The tribunal, we have, there's an order of this court that cases cannot be filed. It has to be returned with a opinion. If the cases of foreigners tribunal are filed, I think they should have come here.
yes, sir. Lordship, may I take it day after tomorrow, Lordship? I also take instruction, Lordship.
Because if it is filed,
Yes,
then we can allow her to appear before the tribunal and participate.
yes, Lordship. Let me get the instruction, Lordship.
Hmm?
Day after tomorrow, Lordship.
That's tomorrow.
One copy of the resolution may be kept during the court meeting.
Give him a copy. If you have a soft copy, it is better.
Yes, yes, Lordship. Soft copy of the resolution.
But see, Boral and for the petitioner and for the respondents. Learned counsel projects that upon acceptance of the service report against the petitioner, by order dated 25/2013, the learned member, foreigners tribunal, within bracket second, bracket close Nagaon, had filed the case against the petitioner. Stop. It is next para. It is submitted that when the name of the petitioner did not appear in the NRC, she has made an inquiry and was informed that the proceedings of, what is the case number?
Yes.
Your Lordship, 182411, Your Lordship.
Where is that?
Page
It is 17, 18, Your Lordship, the vernacular portion. Translated was it 17, Your Lordship.
18. Okay. Foreigners case number 1824 oblique 2011. Was transferred from the Foreigners Tribunal second Nagaon to Foreigners Tribunal 8th Nagaon. Stop. The learned counsel for the petitioner submitted that the petitioner had made an inquiry at the Foreigners Tribunal 8th Nagaon, but she could not track out the proceedings, the record of the proceedings. Next one. Accordingly, the court is inclined to request the learned standing counsel for the FT and border matters to make an inquiry and to inform the court as to the status of the proceedings of foreigners case number 1824 of 2011 dash state versus Musammat Anwara, ANWARA, Anwara Begum, wife of Mojid Sheikh. MJID Mojid Sheikh, SEIKH. Within bracket page 18 of the writ petition. Annexure 1, page 18 of the writ. Next, the learned counsel for the petitioner shall provide a copy of the writ petition with enclosures to the learned standing counsel for the FTN border matters. Next, para list on 17/10/2025.
Item 6.
May I please lordships? Have please, my lord, in this contested case, my lord. This case, my lord, petitioner's father's name,
No, don't tell us father's name. Where is the page number, page of the opinion?
opinion, my lord, page 54, my lord,
54.
page 54.
But Mr. S. Ahmed, learned counsel for the petitioner. And so for the respondents. Page 54. Opinion dated 29 January 2025. All president, FT case number so. Reference police IMDT case number so. Declaring the petitioner to be a foreigner of post 25 in 1971 speed. Notice returnable in 4 weeks, extra copies within 2 days. All for the record. The peer for bail is opposed by the learned standing counsel for the FT matters. Proceeding to projection. 10 days time to take bail of rupees 5,000, satisfaction of Superintendent of Police Border, Borpeta. Please talk to 4 weeks on receipt of reports.
Obliged, my lord, much obliged.
Item 8.
Yes, which page is the?
May it please, your lordship. My lords, impugn order is at page 28 to 32, your lordship. And
22.
petitioner relied upon your lordship. Some executed documents.
Just a moment, tell us the opinion page.
Opinion pages, your lordship. 28, your lordship.
28.
Two things mainly
Tell
pointed.
us why it would be maintainable. You have challenged the order of 2018 now. Your only ground is that lack of legal.
Para 20.
Lack of legal knowledge or something, advice or something.
Lordship, para 20 I have stated, your lordship. Yeah, that's person, your lordship. So.
Did not understand the legal consequence. When I was reading it, I was just introspecting. At times when we pass orders, even we don't know the legal consequences, what would happen if it is challenged before the higher court. We think that we have done right. And we end there. We don't think of the legal consequences of what would happen. It goes to challenge.
Long delays there, your lordship. But
No, but is after you have the copy of the opinion. We don't find it at a good ground.
others documents are your lordship, father's documents are there right from your lordship 1966, your lordship, and also Gabora has issued the certificate, your lordship. Uh, that also shows you that it has relation linkage to the father and daughter. Kindly consider your lordship.
This shows the documents, exhibited documents, exhibit
Lordship. Page 30 may kindly be looked into lordship of the
30.
30, your lordship.
Yes.
Voter list of 1966 of the father, your lordship. And exhibit B also the father, your lordship. 1977, your lordship. 77 is also father, father's name is here, your lordship. Father as well as mother, your lordship. And his name appears, your lordship, from 1989, your lordship. That is at page 41, your lordship.
Your first voters list where your name appeared
89, your lordship, 41 pages, your lordship.
is number 41.
Page 41, your lordship. Lordship, I'm sorry, your lordship. Page 39 also with the father, your lordship, page 39. 39 and 41. Thirty-nine is the translation. Page 40 is the vernacular, your lordship.
But Mr. A. Diwan, learned counsel for the petitioner and Spencer for the respondents. Opinion is at page 28, 22/6/2018. Passed by so and so in so. We were declaring the petition to be a foreigner post 25 in 1971 Spain. In view of the inordinate challenge to the opinion dated 22/6/2018, keeping the issue of maintainability open, it is returnable on, give a date after 4 weeks, returnable on so and so. Extra copies within 2 days, call for the relevant records from the concerned tribunal in the following email address. For prayer for bail shall be considered on receipt of records. List on so and so.
Depublish, your lordship. 1411.
Children's Day.
Item 9.
Item 9 also, lordship, I am appearing for item 9, your lordship. Here in this case, your lordship, this is also is pertaining to your lordship.
Give the opinion page number.
Page number, your lordship.
Next. Mr. Diwan,
Lordship.
not annexed.
Lordship.
Page 23.
Page 23.
Page 20. 13/8/2018.
This is also an 18, but here in this case, what happens is, your
State
lordship.
council is more prepared than you.
Lordship, I'm sorry for that.
20. 20?
3.
So here in
23,
this,
no.
page 24, your lordship, page
24.
24. 24. গন্ডগোল হয়েছে কিছু গন্ডগোল হয়েছে না
Annexure 2.
Yes,
So what happens is that the lordship in this case, here in this case, your lordship, both husband and wife, your lordship, reference were forwarded by the SP order, but case has been registered separately, your lordship. The name of the husband is Noor Hussain. But that case, your lordship, notice already been issued, your lordship. So, lordship, I'm sorry, I cannot right now cannot give the number of the case, your lordship. On the same day, judgment delivered, your lordship. And documents are also like same.
no, but in this case, you did not file your written statement. So your evidence was.
Here in this case, your lordship, written statement file, but after that, your lordship, times were allotted, your lordship given. But despite several times, your lordship could not file
Therefore,
the.
that point now you
Evidence,
are raising after 7 years.
Mhm.
You did not give evidence that you have realized now only after 7 years.
WS file. Only the evidence part. I think for evidence time was given. That is in the opinion para number 4, it has been discussed, your lordship. That case therefore fixed on 3/7/18, 19/7/18.
But please tell me, Mr. Diwan, I have there's something I have to understand. If no evidence is filed, how do you justify your statement in paragraph 27? You say that while passing the opinion, the tribunal did not consider the case on merit.
Merit is only because of the fact, your lordship, why I have been stated here, your lordship, the written statement filed. So subsequent part, your lordship, evidence, for evidence, your lordship, although I have been given time, your lordship, but
No, that's okay. So your submission is that written statement itself is an evidence. So court can, any court or tribunal can rely on the written statement and pass judgments.
lordship, on the, as per CPC, your lordship, that could be done, your lordship.
That can be done. Okay.
But your lordship, when evidence is not been filed, your lordship, that may amount to, your lordship, an expiry
If you
order.
raised the issue of CPC, have you seen order 8 rule 10? Did you ever have the occasion to see that? Just give the CPC. Mr. Diwan. Yeah. We have to thank you for reminding us with your statement. Order 8 rule 10. Please read that.
Order 8. Order 8, rule 10, your lordship.
See, revise my memory.
Order 7. Order 8, rule 10. Wait. May I read, your lordship?
Yes.
Procedure when party fails to present written statement called for by court, where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by the court, as the case may be, the court shall pronounce judgment against him or make such order in relation to the suit as it thinks fit, and on the pronouncement of such judgment, a decree shall be drawn up.
Please come to order 9, order 9.
Order 9, Rafik.
Just come.
Order 9, Rule 12, Rafik. Lordship. Explanation is at 28, para number 28, Your Lordship. Yes, 13, Your Lordship. Para 28.
We are not convinced with the ground explanation given. Okay.
Lordship.
Yes.
Lordship, I have the humble and respectful submission to your Lordship that husband is also, he was also been declared by the Foreigners Tribunal on the
No,
same
but
date,
you
Your
see,
Lordship.
That's okay.
Lordship,
But here you have please come to page 24, paragraph 4. Not
24.
only you defaulted in filing of the evidence, but there you did not even take steps before the tribunal.
Yes, Your Lordship.
So whether you what happened to the other cases will not be a concern. Case was fixed on so and so, on which prayer of the cases will fixed for filing of evidence on 1/8. However, on 4/8, the opposite party has been given last chance for filing of the evidence today, that is 13/8. Till now, the OP neither filed an evidence nor any application or petition showing the reason as to why evidence of the OP could not be filed today. So therefore, you could have availed the opportunity of setting aside the ex parte opinion by filing a review as permissible within
Lordship.
the time allowed, but you did not do so. And therefore, your statement that you were not aware of the legal consequences would not help you.
So, Lordship, as per the information derived from the client, Your Lordship. So, after filing, it's not that they are deliberately absent in attending the court because they have already filed the written statement, Your Lordship. So, after filing of the written statement, Your Lordship, so because of certified copy, Your Lordship, as per information, they could not be filed, Your Lordship. But subsequently, Your Lordship,
some communication that's not been discussed in in my writ petition, Your Lordship. So as per verbal instruction, Your Lordship, there's some gaps are there, Your Lordship, because their place of birth is from different, Your Lordship, and they used to take rent for daily wage labor, Your Lordship. They work there at Jorhat, Your Lordship. So this is that is how, Your Lordship. Some gaps are there, Your Lordship. They are actually place of birth is different. So if you, Lordship, go through the even annexers, Your Lordship, address is in 65 voter list address is Moirabari, Your Lordship. P.S. Lahori Gad in the district of Nagaon, but reference here, but the case has been registered Jorhat because both the husband and wife, they took the house on rent, Your Lordship. They worked there, Your Lordship. So that point of time, some documents are sought for by the police. So that relevant point of time, time was also sought from the police, border police, Your Lordship. So that is how this forwarding report has been forwarded to the Pointers Tribunal, Your Lordship. Accordingly, the case has been registered. So sometimes used to come to Nagaon and sometimes Jorhat, Your Lordship. That is how these gaps are there, Your Lordship. Otherwise, Your Lordship, and they have a daughter also, as per the information studied in the Silchar in some college. If Your Lordship consider on the basis principle of national justice, Your Lordship, so I beg you pardon, Your Lordship, for despite allowing me several times, even couldn't file, Your Lordship, the evidence. Just say last chance me given, Your Lordship. Since she's a lady, on humanitarian ground, no, she's a lady, Your Lordship.
But you don't have a daughter. As per your records, you don't have a daughter. You said that your daughter is studying.
Studied earlier, I studied, now got married, Your Lordship. Just few days back, instruction given, I asked, Your Lordship, got married, Your Lordship. And they told that their daughter studied at Silchar, Your Lordship. That's not been stated in the.
Interestingly, since I have no other work, I just read the petition. Along with the petition, you are given a family tree. In that family tree, you did not disclose the name of your daughter.
Family daughter is there, Your Lordship. I'm certain, Your Lordship. They definitely instructed me.
No, that's okay. We are not doubting you. But we are taking cue from you that the petitioner is not truthful even here.
And
Family tree, she is not given the disclose the name of the.
they only instructed me because of abject poverty, Your Lordship. Further could not proceed with studies, Your Lordship. Therefore, you subsequently got married.
Sorry, in this case, we are
And
not
I
inclined
also,
to issue notice.
I also on good faith believed all this.
No, it's okay. We are not doubting you. Did we say Mr. Devan is not making a truthful submission? We are not doubting you. But we are not inclined in this case.
Lordship, one chance may kindly given.
No, because she did not file her evidence. And therefore, you will have to demonstrate that the finding is incorrect.
Lordship is not satisfied with paragraph 4 of the opinion, Your Lordship.
Paragraph 4, yes. You've seen that, page 24.
Page 24, Your Lordship. May I read, Your Lordship? Paragraph 4.
I have read it. That's why we told you, I have read this. Few moments back, I have read this.
My submission rested on, Your Lordship, It is the acceptance of your lordship only. Because the written statement already been filed, your lordship. So why, your lordship, the petitioner could not file the evidence despite giving several dates, your lordship? Some reasons are there, and so far the instruction given to me, your lordship. Some gaps are there because their original place of birth is at Nagaon district, your lordship. And they took a house rent out there. And that is how, your lordship, some miscommunications are there with the learned council, your lordship. Then, and outside of record, your lordship, when I am submitting before your lordship, that they are engaged advocate out there at Jorhat, your lordship. I told them to bring, your lordship, the certified copies of the, your lordship, the written statement. The engaged counsel, our concern, told me, persuaded me that the tribunal not allowing to, your lordship, this certified copy, your lordship, to give the
No, it's okay.
certificate.
We don't need a certified copy. You already annexed here at page 18,
Yes, sir.
a type copy and or the
So,
written statement at page 20.
so that is how, so I also believe, your lordship, that maybe some communication gaps are there. Otherwise,
So once you don't appear on the before the tribunal and then you come after 7 years to set aside the ex parte opinion, you can't allow that. Sorry, Mr. Diwan, not in this case. We are dismissing it.
lordship, kindly exonerate me, please.
We are sorry. Heard Mr. A. Diwan, learned counsel for the petitioner, and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed, petitioner namely so and so, has assailed the opinion dated 13/8/2018, page 24, passed by so and so in case number so and so, corresponding to SP inquiry number so and so, thereby declaring the petitioner to be a foreigner of post 25 to 1971 stream. Next, the learned counsel for the petitioner has submitted that in this case, the petitioner had filed a written statement, but could not file her evidence on affidavit and exhibit the documents. Accordingly, comma, by referring to the statements made in paragraph
Paragraph 3 of the opinion, your lordship. (21/6/2018) written statement filed.
to statements made in paragraph 27 of the writ petition, comma, has submitted that though the evidence was not filed, comma, the learned tribunal ought to have considered the case on merit and therefore, as the tribunal had decided the matter without affording sufficient opportunity to the petitioner to tender evidence, comma, the impugn opinion is not sustainable. Next paragraph. It is further submitted that the petitioner comes from poor strata of the society and therefore the opinion dated 13/8/2018 could not be assailed on time. Accordingly, comma, it is submitted that as the petitioner is a poor lady who is dependent on labor work for her sustenance, be permitted to contest the proceedings. So it is further submitted that the petitioner had been shifting from one place to another, and therefore some therefore all the relevant certified copies of the documents on which the petitioner intended to rely upon could not be collected, which was the ground for which the evidence could not be given on time. Next part, the per contract, the learned standing counsel for the FT matters has made his submissions to sustain the impugned opinion dated 13/8/2018. Next part. It would be appropriate to quote paragraph 3 and 4 of the opinion, impugned opinion dated 13/8/2018, which is extracted below. It's page 24. Next part. From the above, it appears. No, from the above. Let's say that. As per the procedure prescribed under order 3 within bracket 14 of the foreigners within bracket tribunals bracket closed order from 1964, the foreigners tribunal are mandated to dispose of reference case within a period of 60 days from the date of receipt of the reference from the competent authority. Moreover, as per order 3 within bracket 8 of the said order, the foreigners tribunals are required to give the proceedee 10 days time to give reply to the show cause notice, and further 10 days time to produce evidence in support of his oblique her case. Full stop. In this case, as per the opinion, more than 75 days time was allowed to the petitioner, but no evidence was filed. And on 13/8/2018, neither any evidence was filed nor any petition was filed to show reason as to why evidence could not be filed. Next paragraph. Insofar as the plea of the learned counsel for the petitioner is concerned regarding decision of regarding his submission that the tribunal ought to have disposed of the case on merit. It is submitted that it was submitted that its submission is based on the law prescribed under the Code of Civil Procedure. Full stop. In this regard, we would in this regard, as the learned counsel for the petitioner has taken the aid of the Civil Procedure Code to make his submissions, it would be appropriate to refer to Rule 4 of Order 15 XP 15 of the Civil Procedure Code, which provides that where the summons have been issued for the final disposal of the suit, and either party fails without sufficient cause to produce the evidence on which he relies, comma, the court may at once pronounce judgment full stop. Therefore, in view of the mandate of law under Order 3, within bracket 14 of the foreigners within bracket tribunals, bracket was ordered, 1964, the procedure adopted by the learned tribunal cannot be faulted with next para. Even assuming that for some good reason the petitioner could not file her written her evidence on the date fixed, but in this case, the petitioner had also defaulted in filing any adjournment petition before the learned tribunal, which is reflected in paragraph 4 of the impugn opinion, quoted above. Full stop. In this case, the petitioner has also not availed the benefit of order 3 dash capital C of the foreigners within bracket tribunals, bracket was order, 1964, which prescribes the procedure for setting aside an ex parte opinion. It was passed due to non-appearance of the proceeding before the learned tribunal. However, the time within which such application should be filed is prescribed as 30 days from the date of the order. Next part. No, not next part, same part. However, the present petition to rescind the said opinion was filed on 3/9/2025, which is after a lapse of about 7 years from the date of the opinion. Next, in view of the willful default on part of the petitioner to file her evidence and the inordinate delay in asserting the said opinion dated 13/8/2018, the plea, the submissions of the learned counsel for the petitioner that the petitioner comes from a poor strata of society and is engaged in legal work would not be a sufficient cause for entertaining a belated challenge to the opinion dated 13/8/2018 after a lapse of 7 years from the date of the opinion. Next para, if the opinion is interfered with after lapse of 7 years, it would frustrate the very purpose of the prescription of order 3 within bracket 14 of the foreigners within bracket tribunals, bracket was order, 1964. Full stop. In this connection, the court is of the considered opinion that as the state has doubted the citizenship of the petitioner, it was her responsibility to adhere to the time schedule given in the foreigners within bracket tribunals, bracket was order, 1964. And accordingly, the court is disinclined to take a lenient view of the willful and deliberate default on part of the petitioner to file the evidence within the time allowed. To stop. Next para, in this case, impugn opinion is interfered with, it would amount to giving the imprimatur of the court on the willful and deliberate default on part of the petitioner to appear before the learned tribunal on 13/8/2018, which was the date fixed for filing of evidence. But the petitioner neither appeared before the learned tribunal or filed her evidence. Full stop. There is no explanation in the writ petition with regard to the default on part of the petitioner to appear and take steps before the learned tribunal on 13/8/2018. Next, accordingly, this writ petition fails and the same is dismissed at the motion stage without issuance of notice on the respondents. The learned standing for the registry shall transmit a copy of this order to the Foreigners Tribunal Jorhat. Make it a part of record of case number FTG 898 of 2011 for future reference. We'll take a short break and come.
Obliged. Lordship,
I'm growing old. Instead of referring to order 15, I had referred to a different wrong provision. It shows that I'm growing old.
Lordship, I beg your indulgence, your Lordship. Item number 60 is also I'm appearing, your Lordship. May it be passed over only for a week, your Lordship, today. And making it pass, Lordship.
It's 2017 matter. Let me call the matter because we have been informed by the registry that more than 200 cases of old pending are there. These are not being rotated. So
Lordship.
we'll have to pass orders.
Lordship.
Just-
Obliged, leave obliged.
Item 10.
May I please, Lordship? Lordship, the petitioner is declared a foreigner of post 25th March 1971. by impugned order dated 28/8/25. It is at page 68.
For the petitioner and so for the respondents. Opinion is at page 68, dated 28/8/2025. Passed by so in case number so, reference case number so. Thereby declaring the petitioner to be a partner of post 25/1971. Notice returnable in 4 weeks, extra copies within 2 days, call for the relevant records. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the prosecution, 10 days time to take bail of rupees 5,000 to the satisfaction of SP border,
Sonitpur.
Tejpur. List after province and receipt of.
Meanwhile, who may be protected because of license.
Item 11.
May I plead your lordship? My lord,
Yes, Mr.
impugned order is page 50, my lord. Petitioner has been declared foreigner for, it is held that the petitioner failed to prove the linkage with their father.
Okay, 22.
Page 50, annexer.
No, 22 is the year we are more interested in the year. Okay, 22 is in 3 years. Okay. Had Mr. PC Dey done a counsel for the petitioner and so for the respondents. By same order, page 50, dated 5/12/2022, passed by so in FT case number so, SP border IMDT case number so. They were declaring the petitioner to be a foreigner of post 25 in 1971 stream. Notice returnable on, give a date after 4 weeks, returnable on so. Extra copies within 2 days. Call for the records. To the following email address of the learned tribunal. Next, the prayer for bail shall be considered on receipt of records. Next, in the meantime, if the petitioner, namely so is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police, Border Nagaon, to bring the order to the notice of the said authority. List on Swenson.
14th November.
Upgraded item 37 for orders.
$37.
He's filed reply, madam. We have filed affidavit and he's filed reply. We have already filed. He's also filed reply also. যদি আরম্ভ করে ফেলে যেত প্রশ্ন আমি রিপ্লাই ফাইল পেয়েছি আমি এই করিস আপডেট করেছি নিজে আনা
Petition is not there. Then there is one call for the petitioner. Our Mr. D. Nath, and senior government advocate, along with Mr. P. Sharma, and an additional senior government advocate are present. Next for and justice, the matter stands adjourned today. List on 22/10/2025.
Upgraded item 38 for orders.
On earlier occasion, Lordship directed to file a fresh certificate Lordship, because the earlier affidavit filed by us Lordship lacking in some.
Oh, yes, you made a prayer for adjournment
Yes,
in the morning.
lacking in disclosure of the relevant particular Lordship.
Yes, we asked you to file a fresh affidavit
Yes, it's Lordship. So, within 1 week, Lordship.
within 1 week. You adjourn the matter then? Okay. The petition has been released in the meantime. Released, okay. All sides are represented. On the prayer made by Mr. G. Sharma, and it's standing counsel for the FT and border matters. This case is adjourned today. List on, give a date after a week. Huh?
20.
So make it after that, 27th.
All of the.
Make it 27th, we are making it.
27.
27th Monday. You're giving more than 10 days.
Yes.
Item 39.
The
Yes.
petitioner had earlier approached this honorable court, my lord, regarding, my lord, her wife, my lord, his wife was picked up, my lord, and my lord, and then in that proceeding, it was informed, my lord, that she had been, my lord, deported, my lord. Now, my lord, therefore, my lord, we filed a subsequent application, my lord, because they did not produce, my lord, any, my lord, handing over letter, my lord, or handing over, my lord, note, anything of that sort, my lord, nor, my lord, the nationality verification reports, my lord. So, my lord,
Yes, Mr. Sharma and Mr. We issued a notice.
yes, my lord, lordship
Return
issued a
today.
notice, my lord.
Lordship, what is Lordship present status? I don't have instruction, Lordship.
No, not
Okay.
that. Its status, the status that it has been deported back to Bangladesh.
Yes, Lordship.
But he said that it is without due process of law.
Yes,
And therefore you will have to file an affidavit in this case.
yes,
Correct.
yes, Lord. Oh. Oh, yes. Yes, Lord.
Well, instructions here. And please inform who is the CGC appearing today? You inform him also.
Yes, in criminal matter, MR Odhikari is appearing, Lord.
Amar Adhikari is open. Whatever you speak, tell them.
Yes.
But today the appearance of if who is shown. If Mr. Adhikari is there, please tell him also.
Yes.
All sides are represented. We give them time, 2 weeks time. Sides are represented. Mr. G. Sharma, the standing counsel for the FT and border matters, praised for some time to file an affidavit in the matter. Next para, in view of the nature of grievance raised in this writ petition, among the respondents shall file their affidavit in opposition at least 2 days prior to the next date of listing. Next para, list on 29/10/2025. Please inform Mr. Adhikari also.
Yes, sir.
Oblige, your lordships.
Upgrade item 40 for orders.
This is a loss. And of this IA is while seeking bail lordship. The petitioner is in custody from 28/5/25.
Pardon me, from
28/5/25. As on today,
28/5/25.
141 days lordship. 141 days as on today lordship.
Sharma, we are raising the petition on bail. It's more than 100 days. It's there. The records are received.
Yes, lordship.
It's audible piece in the IA. Huh? Heard Mr. M.I. Hussain, learned constable, the applicant also heard so and so for the respondents. Next paragraph. By filing this interlocutory application, the applicant is seeking bail in connection bail on being apprehended pursuant to apprehended on
28/5.
28/5/2025 in connection with an ex parte opinion dated 2/9/2024 passed by page 8, passed by so and so in FT case number so and so, reference number so and so, thereby declaring the applicant to be a foreigner or post. Is declared to be a illegal foreigner. Only that much. Next paragraph. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that the petitioner had defaulted in appearing and contesting the proceedings drawn up against him. And that despite granting of reasonable opportunity to the petitioner, he did not take steps before the learned tribunal for filing of written statement and to give evidence in the case. Next paragraph, be that as it may, as the applicant has been, it will be applicant, not petitioner. Since the applicant is stated to have been apprehended on 28/5/2025 and has spent about how much days?
141 days.
141 days in custody. Court is inclined to order the order the petitioner to be released, applicant to be released, applicant namely so and so to be released on bail on the following conditions. The three conditions are there. He'll take bail and then SP within 3 working days will. Acha. Mr. Sen, in view of the festivities, we are granting 5 days time to release because there will be a lot of law and order duty in this time. Earlier we said 3 days, make it 5 days here. To have the petitioner released from the transit camp Matia Gwalpara. The accordingly, this interlocutory application stands allowed and disposed of. And in the main case, you say all sides are represented pursuant to order dated 4/8/2025, the records of the traveler is received. Acha. Yeah. I think I said, file written statement. Written statement is file, just say evidence. Yes, what is the ground for not filing of evidence?
If I was stated, I could not take step. There was miscommunication between the learned council and me, Lordship, because I could not afford. That is the main ground I have stated in my petition, Lordship. Paragraph 13 and 17 I have stated.
But you know what has happened? Look at this. Just read this.
That is the reason, Lordship, because I was unable
Give you
to
time,
afford,
we'll not dispose it of today, you see what can be done.
Lordship.
Because if the court is inclined to rule returnable forthwith without filing any press, we take a look. This is the matter for hearing in the second week of November. In the week commencing 10, 11, 25.
Deep love, Lordship.
Item 12 for admission.
Yes, Dr. Party. Yes. Sir. Yes. Yes, sir. Yes, sir. Supreme. This is the order.
M. Rahman Lodge. Rahman, on behalf of A.S. Tapad, I am not the advocate on record.
Within bracket border, bracket was Nagaon. Reference case being case number FT/H/303/2013 was registered before the learned member, Foreigners Tribunal, Hojai, Shankardev Nagar. And the said learned tribunal, by an opinion dated 25/2/2015, upon appreciation of the evidence on record, decided and answered the reference in the negative by rendering an opinion that the petitioner, namely Muhammad Amiruddin, son of late Omar Ali of village Modir Toli, that is, you'll find it at page 11. Modir Toli, Mikir Gaon, under Dopoka police station in the district of Nagaon, is not a foreigner. Last paragraph, page 11. Next paragraph, in the notice which has been issued in connection with FT case number 928 of 2015, the description of the petitioner is Muhammad Amiruddin Muzumdar, son of late Ambar Ali, Modir Toli, Mikir Gaon, Dovoka. This is at page 13. The issue raised by the petitioner was taken up by this court with some connected writ petitions. And this court, by a judgment and order dated 19/4/2018, passed in WPC 7339/2015 and other connected matters. Held that as a legal proposition, principles of res judicata embodied in section 11 of the Civil Procedure Code would not be attracted to a proceeding under the Foreigners Act and the Foreigners within bracket Tribunals bracket close order. Full stop. Accordingly, the writ petitions were directed to be listed separately and decided on their own merit. Next para. In the meantime, a copy of the order dated 14/5/2025 passed by the Supreme Court of India in the case of Swapan Datta versus Union of India civil appeal number. This is flag X, yeah, flag X. Swapan Datta versus Union of India and others, civil appeal number 6799 of 2025 with civil appeal number 6800 of 2025 given that Amir Expert Uddin Mazumdar MAZUMDER versus Union of India and others has been placed before the court. Full stop. Paragraph 4 of the said order is quoted below. This will get in the that Supreme today. Paragraph 4. The paragraph 4 and 13 are quoted below. Full stop. In view of the quashing of the proceedings of FT case number 928 of 2015, pending before the Foreigners Tribunal, Nagaon, by the Supreme Court of India, no further order is called for in the present writ petition. And accordingly, the present writ petition stands disposed of, having been rendered infructuous in light of the order dated 14/5/2025 passed by the Supreme Court of India in civil appeal number 6800 of 2025, within bracket arising from SLP within bracket civil number 7248 of 2019, give a dash, bracket close, give a dash, Amir Uddin Mazumdar versus Union of India, that is flag X. Same name. Second one. Next part, the records of the tribunal will be returned back. Both the records of the tribunal will be returned back. These are already been quashed.
Obliged.
Item 13,
May I please your lordship, I on behalf of Mr. Yasir Ahmed, the matter may be taken tomorrow. My senior is busy in hospital with his father. Yes.
Item 14.
Your Lordship, kindly pass over the matter for the time being. Okay.
Otherwise, Lord may allow her to take the instruction from the client whether she can.
Item 15.
My lord, impugn order page 55. The discussions have started from page 58, my lord. 58, top it will be seen. Certified copy of voter list of 1966, which was obtained in the year 1997, Exhibit 6. And that the name of Khondakar Abdul Majid,
Exhibit number?
6. Page 58.
Where is the document?
Yes, documents, yes. Page 18. Actually, page 14 first, Lordship, kindly see, page 14. This is the NRC of 1951.
This is exhibit number?
This Annexer 1, that is exhibit number 4. In the name of Khondakar Abdul Majid, who is my grandfather. Sorry, he is my grandfather's brother. My grandfather's name is Khondakar Jamaluddin. It is there, page 14, serial number 7.
Just give it this. You see, this is exhibit 6. There's some problem, that's why we,
NRC 1951.
exhibit 6 is voter list of 1966.
No, it is written, my lord, in the
Exhibit
order.
4.
In the order, it is written.
This is exhibit 4. Exhibit 4, okay. 1951.
Space 55 onwards. Then Lordship may kindly say page 59, then it will be clear.
No, it's okay. Yes. Okay.
This 59, Lordship would say, exhibit here now on
No, it's
analysis
okay.
of documents.
It's okay.
It is
we've seen
okay.
that.
Then thereafter, my lord, this is the NRC in the name of my grandfather and father. Father is Khandakar Jamaluddin. His name appears as serial number 7.
Yes.
Now, Lordship may kindly see page 17, my lord. Page 17 is the vernacular prospectus. Wait for it. Page 16. 17 is the vernacular, 16 is the translated copy. So Khandakar Jamaluddin, his name is there. It is exhibit 5.
So this is Khandakar
Page
Abdul Majid.
16. Page 16.
This Khandakar Abdul Majid.
Hello?
This is Khandakar Abdul Majid. Who is he?
He is my father. Then page 18. This is the voter list of 1959. In the name of my father, Khandakar, Jamal Mihar Khandakar, Jamal Mia it is written. Khandakar Abdul Majid, and it is serial number 169. Actually, 169, Lordship may kindly see, 169, page 20.
Who were your witnesses in the case?
Witnesses, my lord, there are several witnesses, and witness DW1 is I myself. DW2 is a Khandakar Budiur Jamal Mia. He is a local old person. Then, my lord, Probin Brahmo, chairman VCDC, who issued the certificate. He is DW3.
Yes.
And DW4 is Turun Chandra Das, video.
Yes.
So these persons have certified that the petitioner is the daughter of late Abdul Mojid, Khondokar Abdul Mojid, and the VCDC chairman issued certificate.
Okay, we'll continue post lunch.
My lord, one problem, my lord. At 2, I have another problem fixed. So thereafter I will come in court number 16.
Okay.
Me also allow due apology.
You don't fix cases, you fix problems.
Item,
Okay.
item 21, my lord,
Yes.
to file reply affidavit. So, my lord, and related matter is pending before the Supreme Court. Can it be adjourned for next 6 weeks, my lord? Because he will also file affidavit.
21.
21. He also file affidavit. I will also file the affidavit in reply. For respond for. So,
Just see this record, item 21. You have filed it or you want to file it?
I have to file the affidavit in reply. And response number 4 is also going to take time for filing affidavit. So, my lord, some time may be given, my lord. This is regarding relating to atrocities by the police, praying for an inquiry, my lord. Government has filed the affidavit, but I have not filed a reply, waiting for the result of the Supreme Court case.
Let's take the memo. Advocates present. Take the memo of advocates present. So are present.
Little bit long date may be given, my lord. Huh? Supreme Court মানে
Uh,
এটা কোন আছে? এটা ফাইল কৰিল ইছ্যু নহয় কিন্তু সেইখন ৰিজাল্ট পালে এফিডেভিটখন ৰিপ্লাই ফাইল কৰিব লাগিব এটা পেন্ডিং আছে যে
you are paying for respondent before. You see, the learned counsel for the petitioner prays for an adjournment to file affidavit in reply in the matter. The learned counsel for respondent before also prays for time to file affidavit in opposition in the matter. Full stop. Mr. P. Sharma, under the additional senior committee advocate, has submitted that the state respondent number 3 has already filed an affidavit in opposition in the matter. And this affidavit of 3 will cover for 1 and 2 also. Or no? Hmm? No, no. You see, we want to be very sure to what is happening. That's why we are asking you. Respondent number 3 is filed. 1 and 2 have 1, 2 and 4 have not filed. Oh, 4 you will be filing. Okay. So 1 and 2 have not filed. So what do we say? We close the matter for 1 and 2. No affidavit. Huh?
We'll take instruction whether filing.
Okay. Full stop. However, it prays for some time to obtain instructions as to whether the respondent numbers 1 and 2 would be filing an affidavit in opposition in the matter. Next. Accordingly, on the joint prayer made, the matter stands adjourned today. List on.
Not analogous case, not analogous. He filed quashing.
No, we are
filed
not
also
interested
4 weeks,
in the
4 weeks, my lord.
4 weeks.
4 weeks, because waiting for result of the stay is
But,
there.
if we tag everything, then no case proceeds.
No, my
Every
lord.
case is kept pending.
Can it be for 4 weeks, my lord? Let the Supreme
Okay,
Court. case
4
for-
weeks. Okay. Accordingly, list the matter on 10/11/2025,
10/11.
10/11. It's okay?
They have taken 4 weeks time on 7th October, my lord, in Supreme Court. Supreme Court, there is a case, my lord. Because the quashing matter, partly it is quashed, partly it is when the petition approached, Supreme Court have stayed. And court is in favor, but the government advocate again and again for 24, my lord, they are taking time. Again, my lord, it depends on the result of the Supreme Court. That's why little bit more, last week of November, my lord. Let it be over, my lord, then my lord, it will
Okay,
easier.
before 11,
Last week of
25,
November,
the affidavits shall be exchanged at least 2 days prior to the next date of listing. Will be filed and exchanged,
24th of November.
filed and exchanged.
Mm.
Okay,
24th of November. Obliged.
okay. This will take it after some time when Mr. Mahmood comes. We may be 5 minutes late in assembling again.
Already argue করেছি।
Item 16 for admission.
My lord, please forward the matter for the time being. Please forward the matter for the time being. Obliged.
Item 17.
My lord, this petition was filed by the state lordship. You can see, and lordship matter was already heard on merit and directed to file written argument lordship. It was not filed till that lordship. If and there was some order lordship I have seen. Lordship. Otherwise, lordship matter may be heard on merit lordship on 28/10/2025 lordship. Another matter was fixed in respect of repetition lordship filed by the state lordship.
I mean, paying for the sole exponent. Am I correct? The order was passed from the, of the material, from record of the. Pardon me?
The order was passed on the basis of the materials available on record. Two witnesses were also examined, the petitioner and her brother. And the documents from 1966 has been exhibited lawsuit for the learned tribunal. And on the basis of materials available in record, the order was passed. Lordship, you can see the order at page 10.
Yes, we have read that.
Lordship. And in the report also, there is a observation, Lordship, you can see page 11, last two lines, Lordship.
Yes.
In the report of IO, there is no mention about address in the country of origin. It means there is no mention from which country OP has entered into India. These things were considered and the respondent was declared as Indian, as a Indian national.
That is not a good reason to declare somebody as an Indian.
Yes.
That means, Lordship, investigation is not proper, Lordship. On the basis of improper inquiry, the order was passed, Lordship. Apart from the documents she exhibited before the learned tribunal, Lordship. They were they were examined, they were also duly cross-examined, Lordship.
But there's no link
Yes.
of the petitioner with her projected parents.
The younger brother adduced as DW2, Lordship.
Younger brother and the petitioner, they also don't have a connection. You see, very respectfully, I address my sister is esteemed elder sister. Correct. Every time you will hear us that she will call me brother and I'll call her sister. Does it create a blood relationship? There's no document at all with either of the brother with the father or the society with the father.
Except the impugned order, Lordship, I have no other document to argue on the
It has to
issue.
go back. It has to be remanded because you see, the finding is that 1966 voter list shows that the so-and-so was the father was in India. But to show that is the father, we are not finding any link. But the date of death of the father is not there, where he died is not there. The photo electoral, the electoral photo identity card issued in 2015. And the names are so common that yesterday when we were hearing a matter, the proceeding and the father-in-law had the same name.
Yes.
Only on the basis of oral statement, Lordship, that opinion was passed, Lordship.
But in DW two claim that the petitioner respondent is the sister, is his sister. That was not rebutted, Lordship, and that could not be demolished, Lordship. Witness of DW two.
No, you know the judgments of this court. You have done more cases than we have handled here in the bench. You know the decision of this court that for citizenship, the oral evidence or a voters is not a appropriate proof. I have given an example earlier also. Maybe you have heard it. I have repeated it more than 100 times. You see, the President of the United States of America, his company holds a land in West Bengal. That is a property I have visited. Supposing I have somebody has a land document of that property, anybody can apply for the record of rights and get it. Correct. Today, maybe X is holding your land documents, we don't know, certified copies. Many scams have come out when the bails are being investigated. On the basis of Jamabandi, certified copy of Jamabandi bails are granted, and thereafter when the people vanish, then the bailers and this land documents are found out to be fake. So supposing that land document of X is held by Y, doesn't make him a relative. That has to be shown by some cogent admissible evidence. We find no connection, in fact. It means the oral evidence was taken into account, whereas the judgment of our court is, it can't be done. You'll have to remand it. You will get an opportunity to file additional written statement and to lead evidence. You know, there's something which we tend to overlook. tell you why. So then we give you this. We will show you in sequence, section 61 to 65. Everything- Yes, first is 61 is proof of contents of documents. The contents of document either be proved by primary or secondary evidence. Now 62, what is that? Primary evidence. Now you see primary evidence means a document itself produced for inspection of the court. See that explanation 1, explanation 2, 3, 4, 5, 6, 7. Therefore now this certified copy of the electoral roll is not covered by the definition of primary evidence within the meaning of section 62. Now please come to 63. '63 is secondary evidence, correct? Secondary evidence includes number 1, certified copies given under the provisions of so and so. So certified copy is a secondary evidence. Now please come to 64. Proof of documents by primary evidence. Now come to 65. You may omit other parts. It relates to cases in which secondary evidence can be given. You omit other part, come to F. Please read that.
When the original is a document of which a certified copy is permitted by this act or by any other law in force in India to be given in evidence.
Yes. Now in this act, there's nothing which permits a electoral roll certified copy to be an admissible evidence. That's one. Second is under the Representation of the People's Act 1950. 51 is the election part. 50 is the substantive part of the voters list. There also you will not find any provision which permits a secondary evidence, the certified copy of this to be a admissible evidence. Correct. But in these cases, what is happening is that the proceedings are not aware of the law. They may not be appropriately guided. So therefore, we have several judgments of this court which says that the primary evidence, it has to be proved by primary evidence. A lot of judgments, even in foreigners' cases, but still we are overlooking those well-settled law, and we are admitting the evidence of the proceedings so far as the voters list is concerned, taking it under the 74 or 76 of the Evidence Act. We are taking a lighter, a lenient view, in fact, of that. But still the fact remains that 66 voters, the tribunal says, has established that the father was a citizen of India. Now, how is the relationship proved? This is not a proof under Section 50 of the Evidence Act. Please see Section 50.
Opinion on relationship when relevant.
When relevant.
When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject is a relevant fact.
So therefore, opinion of the person himself is not a opinion under Section 50. How people perceive. You see, there are many judgments on this point. Here, what happens is that, let us say that a boy has been, or a girl has been adopted, and everywhere the father relates himself as the father of the boy or the girl. School admission registers, everywhere this name is written. And therefore, Section 50 will say how the relationship has to be proved. It is the opinion of a person in the family or otherwise. So now evidence of PW2 is there. But the DW2, he has not shown any document of him with his father except for the voter's identity card. And that is of a different village. Address is different. How is the shifting proved? Shifting is not proved. Now please come to 112. I'm having a new book. I'm not very familiar with this Bharatiya Sakshya Adhiniyam. Please come to 112 of the Evidence Act. I do.
Birth during marriage, conclusive proof of legitimacy. Section 112.
6. 116. Yes, 116.
Burden of proving facts, especially within knowledge.
But during marriage, conclusive proof of legitimacy. Now the mother's name is not even there pleaded. If we claim citizenship and legitimacy of the parenthood also has to be demonstrated. I give you another example. Now, it's only an example. A person introduces somebody as a member of his family, and in Assamese he calls that Lora Nisinai. So everywhere for last 20 years or last 20 years, he's telling everyone this is like my son. Now, existence of continuous relationship more than 20 years with a remark that he's like my son doesn't make the man the man a son. So it's when it's a general perception. So therefore, the proof of legitimacy and the proof of the sonship must be for some reason proved. This happens because of the Section 50. Basically, when you read these judgments, you will find it This originates because of the fact that many in earlier times people used to give children in adoption. The requirement is that you will have to have the datta homam, and that was not done. And therefore, when issues of properties came, then this issues came as to how the legitimacy of how the proof of citizenship can be, family can be made. So under 50, presumption is drawn with the perception. There's a very beautiful judgment, Hwal Sannyasi. Hwal Sannyasi. This is a judgment you don't have to write because you will never read it. In this case, more than 1,000 witnesses were examined. This judgment runs into hundreds of pages. actors representing the petitioners as well as Mr. M.I. Hussain, learned counsel for the respondent. Amicus. Learned amicus curiae appearing for the respondent. Next para. The court takes note of the fact that by order dated 29/5/2017, notice was issued on the sole respondent, and as per the order dated 6/6/2018, the notice was deemed to be duly served, and by holding that the service is complete, Mr. M.I. Hussain, learned counsel, was appointed as amicus curiae to assist the court. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioners being the state of Assam and the Union of India have assailed the opinion dated 15/7/2016 is page 10, passed by so and so in case number so and so, thereby declaring the petitioner not to be a post 25/3/1971 foreigner. 1916. What did I say? Oh, I'm sorry. 2016. Oh, no, this is because of the fact that in the cost title, that mistake is made. Here you said 15/7.
Yes.
Okay, it will be 19/9/2016 as this. She is not a foreigner coming into Assam after 25/1971. Next para. The learned counsel for the petitioner has submitted that there is no cogent or reliable evidence based on which the respondent was declared to be not a foreigner, as the burden of proof lies on the respondent under Section 9 of the Foreigners Act, 1946. So it is submitted that the learned tribunal had failed to discuss the materials on record and reliance was based on the oral evidence to prove nationality. Next, per contra, the learned amicus curiae has made its submissions in support of the impugned opinion. First off, it is submitted that there is a specific finding by the learned tribunal that in the report of the IO, there is no mention about the address of the petitioner in the country of origin. Meaning thereby that there is no mention from which country the petitioner is, the respondents are entered into India. First off, accordingly, it is submitted that the investigation was defective and the reference was made without and without a proper investigation. So it is also submitted that the learned tribunal had accepted the evidence of the respondent as well as a projected brother who was examined as DW2 to the effect that the parents of the petitioner, sorry, the respondent, were present in the year 1966, for which the electoral roll of 1966 was proved as exhibit. That was exhibit 1. Exhibit 1. Huh? Exhibit A. Stop. Accordingly, it is submitted that in the absence of any cross-examination to demolish the oral evidence of the petitioner within bracket DW1 and her projected brother,
May I leave for the time being?
namely Muhammad Abdul Rashid, within bracket DW2, it was the unrebated evidence of the petitioner that she is the daughter of late Ali Hussain, Hussen, alias Ali Hussain, ALI HUSSAIN, whose name appeared in the electoral roll of 1966 from village Porua, PORUWA, under number 77, Tejpur, LAC. Accordingly, it is submitted that the writ petition deserves to be dismissed. Anything else you said? I may have missed it. That's all. Next part. Consider the submissions as well as produce the records of the tribunal. It may be stated that the respondent in her written statement filed before the learned tribunal has stated that her father, late Ali Hussein, Hussein, alias Ali Hussein, Sussain, was a citizen of India and an original resident of village Porua, Pourua, in the district of Sonitpur. However, the petitioner has not made a mention of any of the family members or even her grandparents or her mother, 7, except referring to the name of Muhammad Abdul Rasid, RASID, as a projected brother whose name appeared in the electoral roll of 1997 from number 73, Tejpur LAC, from village Bhitor Suti, BHITORSUTI, from Muza Bhairavpat, BHAIRABPAD, PS Tejpur in the district of Sonitpur. And it was stated that after the death of the father, her projected brother shifted residence to village Garchingia, GARCHINGIA, next word BIHIA, third word Gaon, under PS Tejpur in the district of Sonitpur, and had a elector photo identity card, in bracket EPIC for short. Projected that the name of the petitioner appeared in the electoral roll of 1997. From village Bhojpua, Chapuri, BHOJAHUWA, Chapuri, CHAPURI, Muza Mahabhairav, MAHA, BHAIRAB, under PS Tejpur in the district of Sonitpur. And under 73 number, Tejpur LAC. And that subsequently she had shifted to village Kacharipam, KCHARIPAM, Moza Mahabhairav in the district Sonitpur. Full stop. However, the learned tribunal merely on the basis of the electoral roll of 1966 within bracket Exhibit A, held that the parents of the respondent were present in the year 1966 as residents and voters of village Parua, PARUWA. In this regard, it is seen that in the written statement, the petitioner has not disclosed the name of her mother. And she had also not disclosed the name of her mother in her examination in chief. So therefore, the finding as regards the parents of the petitioner, respondent, the citizens of India, is found to be beyond evidence led by the respondent as DW1. She has not introduced her mother in her written statement or in the in her evidence, nor she has disclosed about the name of her grandparents. Next paragraph. Referring to the observations made by the Supreme Court of India in paragraph 26 of the case of Sarbananda Sonowal versus Union of India within bracket 2005 bracket plus 1 SCC 174. This court in the case of Hajarat Ali HAJARAT Ali versus Union of India, WPC 7386 of 2017 has held that to establish citizenship, the proceeding must provide information regarding date of birth, place of birth, date of birth and details of parents, details of grandparents to prove the claim as a citizen of India. In this case, the said procedure was not followed by the petitioner and by the petitioner. Next para. Next para. In the case of Mohammed MB, Mohammed Babul, BABUL, Islam versus Union of India, WPC 3547 of 2016, decided on 9/5/2018. This court has held that EPIC within bracket electoral photo identity card is not a valid piece of evidence in absence of supporting evidence. In this case, there is no document to show the link between no supporting evidence to link the DW2 with his projected father. Therefore, following the ratio laid down in the case of Muhammad Babul Islam within bracket Supra, the entries made in the EPIC cannot be a valid piece of evidence to prove citizenship of the country. Next, accordingly, the court is inclined to hold that an oral evidence in the absence of any cogent and reliable material cannot establish a proof of the petitioner with a projected father merely on the basis of the electoral roll of 1966 within bracket Exhibit A. Next, and accordingly, court is of the considered opinion that the oral evidence of the DW2 say that the respondent was her sister, comma, is not admissible in the admission in the light of absence of any document to support the said contention. Full stop. In this case, next para, in this case, the admitted case of the respondent is that her father as well as she and her brother had shifted their residence. Full stop. There's no document showing the entire family together. And it's also not shown that all the family members, comma, except the respondent being a married daughter, were otherwise living together. Full stop. Therefore, a standalone entries made in the voter list of 1966 showing the presence of two persons, out of which only only the first person is claimed to be the projected father. And the voter list of 1993 within bracket Exhibit B showing the name of the DW2 without his relationship to the second person named in the said voter list being established. Would not be, comma, in the opinion of the court, there cannot be a proof of any link between the petitioner and the respondent and a projected brother or projected father. The voters list of the electoral roll of 1997 within bracket Exhibit D also does not establish the relationship of the petitioner with a projected father, as the said electoral roll contains as many as 9 names. There's no pleading or evidence to link those 9 persons with the projected father of the respondent or with the respondent. Next paragraph. In view of our work, the court is of the considered opinion that the impugned opinion that This is page 10, 1916 past based on is not sustainable. According to the said opinion is hereby set aside. Next para. The matter is remanded back to the learned ordinance tribunal, Tejpur first, Sonitpur for rendering a fresh opinion after giving an opportunity, a reasonable opportunity of the respondent to appear in the matter and to provide a sufficient, a reasonable time to file additional additional written statement and additional and to lead fresh evidence in support of a defense. Full stop. Next para, the said learned tribunal is requested to give a reasonable time to the respondent to file an additional written statement, if she so desires, or to lead fresh evidence, if so desired, and make an attempt to dispose of the proceedings within as far as practicable within a period of 4 months from the date of receipt of records. And or appearance of the respondent. Next para. We record our appreciation towards the assistance rendered by the learned amicus curiae, who shall be entitled to his usual honorarium by the that's honorarium legal backup legally compatible DLSCD. Look, and how could you be like that? We'll make an inquiry. I forgot who disburses the honorarium. We'll just make an inquiry and we'll add that. He'll entitled to his usual honorarium. You want the time period, you can see it. Time period or the time. We've given 4 months from the date of appearance. 6 months to, because then we'll have to, we'll be rewriting the rules. Yeah. The procedural part is already there. 10 days, and then 60 days. That's why we have given them extra time. Because we can't be overriding the procedural part. Right. Mhm. Itu. Nah, itu biar no.
Item 15.
Yes, Your Lordship. Earlier, up to 16, I have placed the documents. Page 16. My father is Khondokar Abdul Majid. Yes. Yes, 19, 19 or 18, I think, 18. Exhibit number 7. And this is the voter list of 1966. So 66, my father's name is there. That is serial number 86, Abdul Majid. Top of the list. This is the voter list of 1966. Then page 22 is the voter list of 1970. Here also my father's name appears. '66, page 21, serial number 86.
Exhibit number.
This is exhibit number 7. Actually, some problems are there because in the order sheet, this is 7 it is written, but it is 7. If we go to this improved order, that would be clear by the position. Page 55, Lords, you can listen. The page 55, second para, my lord. The proceeding in her evidence adduced by way of affidavit deposed that she is the daughter of Khondokar Jamaluddin and was brought up at village number 2, Sarke Busti of Sarke Busti Gao, Panchayat, under Lanka, Revenue Circle, Nagaon, District Assam, established a link certificate dated 22/7/15, number so and so, exhibit 1. That was the link certificate. That link certificate, my lord, that is here, that is in page 23, link certificate. Given by Panchayat. Here we see in the document, the exhibit number is not seen, but there is the signature of someone of Foreigners Tribunal's office. But exhibit number is not written here. Office seal is there. Then Lordship, again kindly come to page 57. Yes, tribunal is there. But exhibit number is not here. Similar is page 24, that is school certificate. Here is also the office seal of the Foreigners Tribunal, but the exhibit number is written in a different manner, exhibit 2. Exhibit 2. Here it is type original. It is the type original. It is written FT7 DBR 155 1 full stop 15 type original. So here exhibit 2 is written there. So this is the school certificate which connects Saleha, which connects this Saleha proceedee with her father Khondogar Jamaluddin. So it is a link document with my father, whose name appears in 66 and 70 voter lists. Other documents are there. Other documents are coming. It was issued by the headmaster. And how the BDO can say this, whether he is a competent person? Linked document is several documents. One has been issued by.
If one goes, the second cannot sustain the school certificate, which is exhibit 2. You see, this certificate shows that the party has left the Puran Bijni Batinia ME Madrasa on 31/12/1993.
Yes.
This certificate was issued on 2011/2015.
Yes.
We don't see that the headmaster was examined, but you did not say about you said about 4 witnesses only. One is the petitioner, 2 is the local person,
Yes.
3 is the chairman, 4 is the BDO.
These 3, my lord, these 3, who is the PCDC chairman, he has also given a link certificate and a certificate.
Who is this VCDC?
PCD Village Council Defense, it is within BTC, Village Council Defense Committee.
But you know, this, we don't know about VCDC, but the village defense committees, they are under the Assam Police Act. They don't have the power to give any certificate.
Well, it is in BTC area, they have some certain procedures. And the different subject matters have been entrusted to them also. Accepting law and order, other powers have been provided to them.
I don't know.
BCDC chairman, his certificate is 120. For a moment, Lordship, kindly come to 120.
We have seen that we are looking at the original one. The original evidence we are reading.
And next one, Lordship may also kindly go through the impugned order where different public documents have been exhibited. That is page 55 onwards. And those are also written by the learned member. So there is no reason as to why this document shall
A
be leaved.
few questions. You see, we have tried to look at your written statement and the evidence led. Now you see, your case is that the petitioner got married to Aijol Hawk of village Bengal Doba Relief Camp.
Yeah.
Correct.
Yes.
The year of
Bangaldova is in Pokrajhar district.
No, very well. But this date of the year of this marriage is not given. At least I could not find it. I may be wrong. This date of marriage is not there. And now this certificate says that this exhibit 3 says that the name of the father of the petitioner is found in the electoral roll certificate of 1966.
Yes.
How does he have that knowledge?
Well, apart from that, if your lordship is on that, that is page 27. Page 27 is also a linked document. It is given by VCDC, and he has adduced
That's-
evidence that I personally know.
That's what we are saying. You see, with I would fail to understand because you see, Mr. Mahmood, you have seen in the bench. You have seen me every day. I meet the same learned counsel, but I forget the names. I always have to ask. 360, 210 days a year. For last so many years, I've been asking names of same learned counsel whom I'm interacting with daily. Correct. So will I remember the name of the uh, father-in-law of a resident? The lady was married to Ainul Haq of this village. So for this village, the father of the petitioner would be a father-in-law. Would somebody remember the name? And somebody will know it.
My lord, my submission is a little different, lordship. If your lordship kindly see
It's not on that. You see,
page 27.
no, you see, we are on, I'm on a different.
I am
text.
convincing you, my lord.
No,
I hope
please-
you will be
please hear us,
convinced.
Then you will convince me. Now you see, first of all, the constitution of VCDC, you'll have to tell us. Number two, you'll have to show that he has a public duty to maintain the records of the parents of the wife of one person. Personal knowledge means that he's not certifying from a document, he's certifying from his personal knowledge. And for personal knowledge, we already have law laid down that it can't prove citizenship.
No, if he directly comes and adduces evidences, then I think that
Correct.
is acceptable. If
Correct.
he directly comes, only certificate is not enough.
It will not come. I can give you examples. I'm good in giving telling stories. I can give you good examples. Now let me tell you. I think this Taj Mahal is my property, and I make a statement before this court that this Taj Mahal is my property, and 2 or 3 of you, in order to please me, say that yes, Lordship, we agree. This Taj Mahal is your property. And everybody is ready to give me an affidavit. 2 or 3 people of amongst you are ready to give me an affidavit that according to your personal knowledge, Taj Mahal belongs to me. Now, will it create me a property?
Well, nobody will dare to say lie
Why not?
about that.
Why not? If I am to please you,
Here VCDC is like Gawura, madam.
we don't know.
Gawura has no office.
We don't know, but he does not have. You
So
see,
he cannot maintain his record.
no.
properly.
That argument will not lead us anywhere because of the fact that he must give deposition on the basis of some contemporaneous records.
The records, my lord,
To
records
have a
are-
record of father-in-law of someone is just marvelous. If we had such good people in the country, we would have been in a better place.
So, my lord, here,
You see, I'll give you a simple query, Mr. Mahmood. I'm just sorry, I'm dramatizing. Nothing, no intention to hurt anyone. Having the counsel, you find her to be of good assistance to you and keeping her. Maybe in a rare case, you would know her because she was recommended by her father to you, and therefore you know her father well. But always, for example, you may know her father, but if I ask Mr. Gunjan Sharma, you are meeting him every day, what is his father's name? You may not know, because that is not the inquiry required to be made.
normal it is.
So why would a VCDC keep a track of the father of a lady who is a married lady to that village?
Because of, she belongs to her own area.
That's
She
why we are
belongs to her own
asking.
area.
That's why we are asking. You may know me. being the village defense party, you will know me. But to know my wife's father,
No, that is on the basis of record, man. On the
is
basis of
that?
record.
so that's why, you see, you have come there after a long circuitous route. If there is a record, then please show us the record. The evidence standard is beyond record. It is by personal knowledge.
This certificate that is, let me then again say,
61,
20
62, 63.
27 is his certificate.
61, 62, 63 of the Evidence Act takes away everything which you have built up. Evidence must be primary evidence.
Primary evidence and my lord, here primary evidence has been given, my lord.
No. That's no statement by knowledge.
First kindly, lordship, kindly see, page 27.
So we have seen it, we have evaluated, that's why we
So
have
it
started
is
you asking.
on the basis of record, because village serial number 7, house number 57. So he is not telling from his personal experience. So serial number 7, house number 57, under the district Bongaigaon, Miss Saleha Khatun is the daughter of Khondogar Jamaluddin, is known to me very well. So he has referred the serial number, house number, and on the basis of that, he has issued the certificate.
He-
And if your lordship may kindly see his evidence, his evidence is very natural.
This, has this man, Ali Akbar Mia, deposed as witness?
His witness was Khondakar Jamal Mia, Praveen Brahma, that is the VCDC chairman, and Tarun Chandra Das, he is the BDO.
So this writer of this Bengal Duba Relief Camp Committee,
Yes.
he did not come and depose for this certificate. This name, Muhammad Khandakar Jamaluddin, appears in the voter list of 1951. Correct?
Yes.
1951 voter list.
My lord, relief
Is-
camp is
No, it's okay. But
short
this-
measure, my lord.
no, that's okay.
There are some disturbance, so
No,
some
no,
people.
whatever we are not on that. Where is the 1951 voter list?
51 NRC. 59 voter list is there.
No, no, no.
NRC 51 is there, page
So
14.
Therefore, you are answering my query. You see, this certificate says the name appears in 1951. 1951 voter list, even you have not proved it.
No.
So therefore, he's giving certificate on the basis of a document which is non-existent. And in NRC of 1951,
Yes.
you see, the age of the father is not there. The father of the age, the father's name appears in 1959 voter list, where his age is 46 years.
My lord, actually in original, age is not given.
In page 18, you have given that. We have,
No, I am on NRC, page 14. Here my father's name is there, Khondakar Jamaluddin, but
I-
age is not there. Because in original, there is no age.
Mr. Mahmood, I have said that. And therefore, I have come, 51 is not there. I have come to 59. In 59, the father's age is 46.
Yes.
Correct.
Yes.
So therefore, if he's, if in 1959,
Yes,
he is 46,
46.
then he was born in 1913. And whoever is this author of, you in your written statement, you have not said when the father died.
No, that is not so.
It's not there. Now this man, whoever he is giving that certificate, which you said is at page
Yes, my lord. in-
27.
In rural area, my lord, people normally say different type of ages, but here
No,
is
that's
the
okay.
voter ID
No,
card.
no, that's not the
Voter ID
issue.
card of my father.
That's not the issue. Where is that? Voter ID card?
Voter ID card, page 32.
32.
Yes. Jamaluddin,
Yes.
and
he's-
he's.
he's
uh,
1983 in the year,
Yes, 83 years.
this is
83
in
years,
2013.
2013. One 2013.
So there's a difference of 17 years.
Huh?
From the documents, there's a difference of 17 years. 1 or 2 years we can understand, but
In 59, 46 years.
46 years, which makes him born in 1913. 2013, he is 83 years, makes him born in 1930.
Let's say this on record. I
We
cannot
know
go beyond record.
And you see,
But my submission is this one, why VCDC certificate shall not be believed? He is an not
author did not come to prove it.
my lord?
Author did not come to
No,
prove
he
it.
has proved, he has come.
We are
Praveen
asking you, you said no.
No, Praveen Brahma has come, chairman of the lordship said they were the chairman of the relief camp.
He's there, VCDC, he's
VCDC is
DW3,
here, my lord.
DW3.
And he is Praveen Brahma. Exhibit 3 is his certificate. Why his evidence should not be believed? And there is no any reliable cross-examination on their part.
Just a moment. We'll have to continue some other day. My esteemed sister has bench. Take it up some other day. But you read the constitution of VCDC in the Bodoland Territorial Region. You'll find it an interesting reading. The function of the VCDC includes maintenance of records, assisting in the implementation of schemes arranging meetings and ensuring the government funds and resources are correctly used. They've got no business to know about the uh, father of the wife of a resident, because the father would not be a beneficiary of any government scheme. Father-in-law of the resident would not be entitled to any benefit of the government scheme. So therefore, contemporaneous records cannot exist. We'll take it up some other day.
Yes, I will argue on that point. Gaura certificate and VCT certificate are of same value. And Gaura's post is a public post.
No, it is not, because you see, I have a bad habit of reading it.
Yes,
This
I
is-
understand.
This is something which I have opened, and then from an authentic source, I am reading it.
As per section 163 of the Assam Land and Revenue Regulation, the
No,
Gaura.
some land revolution doesn't apply for the VCDC, because the VCDC would not have the authority to change the nomenclature.
Okay, like that, that's fine.
Both sides are represented. The submissions of Mr. M.U. Mahmood, the counsel for the petitioner, remains inconclusive. List as a parted matter on 23/10/2025.
Item 46, madam.
Just to the court master.
Item number 20, madam.
Just two
Okay.
matters.
That may be taken off. Item number 20, madam, there was the direction to pay interim measure, madam.
Oh, yes.
The amount and the amount that they have taken up for some new taken up to be initial impact. The about they have been guessed about the about. But it may be I portal was initiated. No. 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 No.